Joining me now is Tim Parlatore, a former lawyer for Donald Trump. Mr. Parlatore, thanks so much for being here tonight. Let me just first get your thoughts. I mean, how much stock would you put? I mean, how optimistic, I should say, are you that the judge in this case is going to be receptive to the argument that Trump's legal team is making here, that it's a denial of due process if there's a speedy trial?
Well, I think that a lot of what he said there was more, designed for the viewing public, not necessarily for the judge. Really, when you look at how federal criminal cases are scheduled, the idea that it's going to be a couple of months is just not practical. That in order for this case to go that quickly, essentially the defense would have to waive motions. You'd have to, waive certain defenses. And there's a lot of significant issues in this case. We had litigated some pretty significant issues in the grand jury phase related to privilege, executive privilege, things like that. And a lot of those will have to be revisited here. There's a lot of discovery that they're going to go through. The discovery in this case, I think, is going to be far greater than that which is in the Mar-a-Lago case, obviously, without classification issues. And so the idea that this thing would go to trial in under 15 months, setting aside any election, is just not practical from a standpoint of how federal criminal cases are tried.
That's interesting because there's been a lot of attempted tea leaf reading about when Judge Chutnick might actually schedule this. You're saying reasonably is 15 months. Would you be, how surprised would you be if it was considerably earlier than that? And by the way, what avenues of appeals exist if the judge does decide to do this, let's say within this calendar year? I mean, does the Trump team have any recourse if that ends up being the case?
The ability to go to the appellate court in the middle of a case is pretty limited. But really, all they have to do is file motions. Once you file motions, then they have to set out a motion schedule. The D.C. local rules, set out what those normal timelines are. And then you have to have oral arguments and everything. And it's one of those things that will just naturally push the case out further. Plus, I always believe you don't want to ask for such a long adjournment right in the beginning. You want to get the discovery. You want to, go through and start to litigate the case. That way, when you go back to the judge and say, hey, we need more time, you can show the judge, this is how much discovery we have. This is how far we've gotten into it. These are the problems that we've had. The government's not just going to give you all the discovery. There is going to be discovery issues where you want them to give over things that they've withheld. And then you can go to the judge with something solid and say, we need more time because of all these things. And then it's very difficult for a judge to say, go anyway, because that's something that gets reversed.
Okay, so obviously it's a work in progress. The defense is obviously a work in progress. One of the main lines of counter argument that we've heard floated in recent days by John Lauro, the president's defense attorney in this, or one of two, is this notion that he was simply relying on the advice of his counsel. And in this case, one specific lawyer in particular, lawyer John Eastman. I wonder if the Trump team does use that argument, just to set aside its merits for 1 minute, does that not mean that Donald Trump has to take the stand?
No, not necessarily. Not necessarily. A lot of this can be done through cross-examination and through presentation of other witnesses. Because ultimately, yes, if you're presenting an advice of counsel defense, that does bring in an affirmative defense where you have to put on evidence, which you could do through calling John Eastman, theoretically. But I would instead look at it from the perspective of the counsel, special counsel has to show beyond a reasonable doubt that he acted with corrupt intent. And if you instead use that element to undermine his knowledge that there was no fraud in the election by bringing in all the evidence of the things that you were presented by Rudy Giuliani, by John Eastman, by all these other people, that is a better route to do it. And it's not quite as narrow as advice of counsel. It's a little bit broader than that.
But I think it's interesting because the person who could probably articulate the best defense, or at least the most fulsome defense in this, is, of course, the former president. But it doesn't sound like the defense team wants to put him on the stand. Do you think it's a good idea to put Donald Trump on the stand?
That would be a decision for them. I will tell you that in my experience, I hardly ever want to put my client on the stand, no matter what type of case it is. Yeah, that's something you only do in very rare circumstances. And after I have personally cross-examined that client significantly and significantly harder than what I think that the government will do to make sure that they withstand my cross-examination before I even think about exposing them to the government.
Okay, especially maybe if that client is Donald Trump. But we'll table that for right now. In terms of the
I can see problems with that.
Yeah, it sounds like it. Bill Barr does not think that the president should be on the stand under any circumstances. And I'm reading between the lines, and maybe you agree with that?
I think that that's probably a good strategy to keep him on the stand.
Let me ask you about just a parallel federal case, which is the Mar-a-Lago case. Now, there is a lot of talk for people who have been very January 6th focused. There's some interesting movement in that case this week. And yesterday, Jack Smith, special counsel, asked the judge in that case, Eileen Cannon, for a hearing to discuss whether the main defense attorney in that case, other than Trump's attorney, Stanley Woodward, is representing too many clients in that case. He represents 8 people in the Mar-a-Lago case, including Walt Nauta, Trump's named co-conspirator, and then 3 witnesses who may be called to testify at trial in the case. He used to represent Yuscil Taveras, who is a star witness at this point. Do you think Stan Woodward has too many clients and maybe conflicted here?
You know, that is a relatively standard motion in multi-defendant cases. In the Second Circuit, we call it a Curcio motion, where it's not necessarily always used to conflict an attorney out, but rather to make sure that if there are conflicts, that the defendants fully understand those conflicts and knowingly waive them. So, for example, in this case, Walt will be asked by the federal judge, do you understand that any confidential information that Mr. Woodward got from Mr. Taveras, he will not be able to use that to cross-examine him? And do you still want to be represented by somebody who is, essentially handcuffed from doing that portion of the cross-examination? And, then it'll be up to Walt to make a decision on that. So, the more people you represent, the more, risk that there is of conflicts like that. But ultimately, it is the kind of thing that a judge can go through and decide, is this something that's waivable? And up to the defendant, do you want to waive it?
What would you do?
If I were who?
If you were
Walt or Stan?
If you were Walt Nauta. I mean,
or the judge.
It depends, right? But let's say if you were Walt Nauta, would you still want to be represented by Stan Woodward?
Well, here's the thing, is that while Stan may not be able to cross-examine Yuscil, his local counsel can. As long as you have another attorney who's representing you who doesn't have the conflict, then, and I've done this in cases before where you have the one conflicted lawyer that when that witness gets up on the stand, that lawyer just goes and sits behind. So that is something that certainly it'll be up to Walt as to how much he believes in and trusts Stan and how much of a relationship that they have. And I would think that he probably would be willing to waive that conflict to keep Stan on and just have somebody else conduct certain portions of the trial.
Well, especially if Mr. Woodward's legal bills are still being paid by Mr. Trump. We'll table that for another discussion. I got to ask you one last one. In reading this indictment, back to the January 6th indictment, we know who 5 of the co-conspirators are. Do you have a theory on who co-conspirator 6 is in the January 6th indictment?
I've heard a couple of theories, and
do you embrace any of them?
To me, it kind of goes back and I don't want to put all my money on one of them, but I would say between Mike Roman and Boris Epshteyn, those seem to be the most likely people. And really, I would put money a little bit more on Mike Roman simply because it says political consultant, whereas the other ones identify them as a lawyer, and Boris does have a license to practice law.
So Boris's CV is the only thing that is keeping Mike Roman as your number 1 candidate. We'll return to you, Mr. Parlatore, once the co-conspirator 6 is unmasked. I deeply appreciate your time and thoughts tonight, though. Thanks for joining me.
All right. Thank you very much.